Hello Matujima and you're watching HornbillTV. What is Fcra? Let's start with the basics. Fcra stands for the Foreign Contribution Regulation Act. In simple terms, it is a law that regulates foreign money and foreign hospitality received by individuals, associations and organizations in India. So, if an eligible organization receives money from outside India, there are certain rules it has to follow. It may need Fcra registration or prior permission. It has to use the prescribed banking arrangements, keep proper financial records and report where the money came from and how it was spent. The main idea behind the law is simple: to make sure foreign funding is transparent and accountable and to regulate any possible influence that money from outside India could have. There has been quite a bit of discussion about the proposed Foreign Contribution Regulation Amendment Bill 2026. The bill was introduced in the Lok Sabha on 25th of March 2026 and is still under parliamentary consideration. But there's another important update. The Fcra rules 2026 were notified on 22nd of June 2026 and these rules are already in force. Supporters of the proposed changes say that they could make the system more transparent and improve accountability when it comes to foreign funds. But critics have a different concern. They say the changes could make things more difficult for NGOs, charities and civil society organizations, especially because of the stronger consequences that could come with the non-renewal of cancellation of Fcra registration. So, what exactly is changing? And perhaps an even bigger question is, why does India regulate foreign contributions in the first place? Today, let's break down what the bill actually proposes, what the government and critics are saying and where the legal position is still being debated. Because with Fcra 2026, the question isn't simply regulation versus no regulation. It's about finding the balance between transparency, national interest and the freedom of legitimate organizations to function. Let's start with the first big claim. Is India creating a completely new law to stop foreign funding to civil society? Not quite. The Foreign Contribution Regulation Act or Fcra is not new. India first introduced the Fcra way back in 1976. It was later replaced by the Foreign Contribution Regulation Act 2010 and that framework was amended again in 2016, 2018 and 2020. So, the 2026 bill is not starting from scratch. It is another proposed step in a regulatory system that has already been around for about 5 decades. But here's something important to understand. Fcra does not completely ban foreign contributions. Eligible organizations can still receive foreign funding through registration or prior permission as long as they follow the rules, reporting requirements and other conditions. At the same time, certain individuals, organizations and activities are restricted or prohibited under the Act. And thousands of organizations continue to receive foreign funding for things like healthcare, education, disaster relief, research, social welfare and humanitarian work. But just because there are legal channels for receiving foreign money, that does not automatically mean every organization finds the process easy. And it also does not mean the system has no restrictive effects. At its core, Fcra is about one thing: knowing where foreign money comes from, who receives it, and where that money eventually goes. And that distinction matters. Foreign partnerships can do a lot of good for Indian civil society, but foreign money can also bring economic, political, or institutional influence. So, the basic idea behind regulation is that foreign assistance can be completely legitimate, but its source and use should be traceable and governed by law. Now, let's look at another claim. Has Fcra completely choked off foreign funding to NGOs in India? The numbers give us a more complicated picture. Foreign contributions received by registered organizations reportedly went up to around $1.2 billion in 2010 to 2011 to about $2.67 billion in 2024 to 2025. These figures were cited by the Indian government and reported publicly. So clearly foreign funding has not disappeared, but at this is important, these numbers alone does not tell us the whole story. They don't tell us how many organizations lost their registration. They don't tell us how many failed to renew it. They don't tell us how many projects had to be stopped. And they don't tell us whether foreign funding has become concentrated among a smaller number of organizations. There's another figure worth looking at. India has a very large voluntary sector, with commonly cited estimates of more than 3 million NGOs or voluntary organizations. But that number needs to be treated carefully because it can include different kinds of registered and unregistered organizations. Now compare that with the Fcra portal, which reportedly showed 14,449 active Fcra certificates. That is not exactly the same as the approximately 16,200 associations reported as active and having received foreign contributions during 2024 to 2025. So the bigger point is this: Fcra directly applies to only a small part of India's huge voluntary sector because most organizations simply don't receive foreign contributions. But for those that do, there are some basic requirements. They need registration or prior permission. They have to use the prescribed banking arrangements, maintain financial records, and report how the money was used. The purpose is to create a financial trail. It is not, at least in its stated form, about deciding what an NGO should believe or which social cause it should support. However, compliance can still affect how easily an organization operates. So perhaps the better question isn't simply, should there be regulation? The question is, are these rules clear, proportionate, predictable, and fairly enforced? Because India's civil society plays a pretty important role. NGOs run schools and hospitals. They help people after floods and earthquakes. They work in remote villages. They support people with disabilities. They work on environmental issues and conduct research. In many cases, they do things that governments themselves may not always be able to do. So, a strong civil society needs something very important: public trust. And transparency can help build that trust. If an organization can clearly show where its money came from and how that money was spent, people can better understand and evaluate its work. It can also help separate legitimate organizations from those that may misuse charitable structures. But there's another side to this debate. Foreign funding can sometimes be connected to politically sensitive issues, advocacy campaigns, and public policy debates. And it is reasonable for citizens to want to know when an organization involved in public debates is receiving significant financial support from outside India. But knowing that information does not automatically make that organization illegitimate. It simply gives people more information to judge its work. And there's an important line here. Foreign funding by itself is not proof of wrongdoing, political disloyalty, or a threat to national security. So, the Fcra debate should not be reduced to national security on one side and civil society on the other. India needs both effective oversight and a strong independent civil society. Now, here is where this national debate becomes particularly relevant to Nagaland. Churches and Christian organizations in the state are involved not only in religious activities, but also in areas such as education, healthcare, poverty alleviation, disaster relief, livelihood support, and social welfare. The Chief Minister has pointed out that more than 90% of the state's population is Christian and that many institutions serve people in remote, economically weaker and underserved areas. Churches and charitable organizations run or support schools, colleges, hostels, hospitals, health centers, orphanages, elderly care facilities, community programs, and relief operations. Some of these activities have historically been supported through legitimate foreign contributions and partnerships with international organizations. So, any change in the rules governing foreign funding could have a direct impact on organizations working on the ground in Nagaland. And the concern isn't simply whether foreign money will continue to be allowed into the state. It is about what happens if an organization loses or fails to renew its Fcra registration. That could create uncertainty for organizations that depend on foreign contributions to run long-term programs. And there are also concerns about what could happen to certain assets connected to foreign funding. We'll come to that in a moment. For now, it is important to note that the impact would not necessarily be immediate or uniform across Nagaland. Organizations that remain properly registered and may continue to receive foreign contributions. The greater concern would be for organizations whose registration is cancelled, suspended, expires, or is not renewed. This is why the issue has attracted attention in the state. Chief Minister Nipirio has written to Union Home Minister Amit Shah after consulting Christian leaders, the Nagaland Baptist Church Council and the Bishop of Kohima. He has called for wider stakeholder consultation and suggested that the bill be referred to a joint parliamentary committee for detailed examination. Rio has acknowledged that the government has a legitimate responsibility to prevent misuse of foreign contributions and ensure transparency. At the same time, he has argued that genuine educational, healthcare, humanitarian and charitable organizations could not be placed under unnecessary uncertainty. So, for Nagaland, this debate is not simply about foreign money, it is about how the rules could affect institutions and communities that rely on these organizations for essential services. And that brings us to one of the most debated parts of the proposed bill. So, what happens next? There is now a pause in the process. The Fcra Amendment Bill 2026 is being moved towards a Joint Parliamentary Committee or JPC for further examination. This means the bill will get another round of scrutiny before the Parliament decides what happens next. The committee can examine the proposed provisions, hear concerns from different stakeholders and recommend changes. But one thing is important to understand. Being referred to a JPC does not mean the bill has been scrapped. It simply means the proposed law will undergo further parliamentary review before it moves ahead. And for states like Nagaland, where churches, NGOs and community organizations have raised concerns about the impact of tighter foreign funding regulations, this review could be particularly significant. Now we come to one of the more controversial parts of the debate. Will the new bill simply seize NGO assets? Well, the details matter here. Asset vesting provisions are not being introduced for the first time by the 2026 bill. Under the 2010 Act, foreign contributions and assets created from those contributions could already vest in a prescribed authority after an organization's Fcra registration was cancelled or surrendered. What the 2026 bill does is expand and spell out that system in greater detail. It proposes creating a designated authority that would be responsible for the vesting, supervision, management and disposal of foreign contributions and assets in certain situations. This situation could include cancellation, surrender, expiry without renewal and denial of renewal. The bill also provides for provisional vesting in certain cases. So, if an organization gets its renewal, restoration or a fresh certificate within the prescribed period, its assets and unused foreign contributions may be returned through the legal process. But the return should not be described as automatic. And if the organization does not get the required approval within the prescribed period, the vesting could become permanent. Those permanently vested assets could then be transferred to a government body or dealt with in another way allowed under the bill, including disposal in certain circumstances. So, saying the bill will simply seize all NGO assets would be inaccurate. But it would also be wrong to say this is merely an administrative or temporary custodial measure. The bill does create the possibility of permanently losing control over certain assets. Critics have also raised concerns about assets that were partly created using domestic funds, the lack of a clearly defined timeline in some situations, and what avenues of appeal would be available when renewal is denied. So perhaps the fairest way to put it is this. The bill creates a more detailed and potentially more powerful system for vesting assets, but it also includes a mechanism for restoration. There's another specific issue here, places of worship. The bill contains provisions dealing specifically with assets that are places of worship, but the legal material reviewed does not establish that these assets must be transferred to an Fcra registered organization belonging to the same faith. Instead, the bill requires the management arrangements to preserve the religious character of the place of worship. And that distinction is important. The management of such property may be entrusted to another person or organization according to the prescribed procedure. But the protection identified in the bill is about preserving the religious character of the place of worship. It does not expressly guarantee that the property must be transferred to an organization belonging to the same faith. So it would be misleading to say that religious institutions will automatically lose their places of worship. But it would also be misleading to say that transfer to an organization of the same faith is guaranteed. Ultimately, what happens would depend on the legal procedure, the rules, and how the designated authority uses its power. Now let's come to myth 4. Now another question that often comes up is FCRA targeting a particular religion or community? The FCRA framework is written in terms of organizations receiving foreign contributions. It applies regardless of religion, ideology, or community. The basic legal question is generally, is foreign money being received and used according to the rules? Not which religion does the organization belong to. So, faith-based organizations can carry out permitted welfare, charitable and religious activities as long as they follow the Act, the rules, and the conditions attached to their registration or prior permission. There are still restrictions, including rules about what foreign contributions can be used for, and the 2026 rules and related provisions also bring in specific compliance conditions. So, the legal framework should not be presented as giving unrestricted permission for every kind of religious or advocacy activity. At the same time, regulation needs to be neutral, predictable, and applied consistently. That matters not just for constitutional fairness, but also for public confidence in the system. So, is India the only country regulating foreign funding? Not really. A number of democracies have introduced disclosure or regulatory system dealing with foreign financial influence. Of course, their laws are not the same as India's FCRA, so direct comparisons need to be made carefully. But the concern itself is becoming more common. Governments want greater visibility over overseas money that could influence domestic institutions, political activity, or public affairs. However, just because other countries have foreign funding laws does not automatically mean that every restriction in India is necessary or proportionate. India's system has to be judged based on its own constitutional requirements, security concerns, administrative practices, and, importantly, its impact on legitimate civil society work. So again, the key question is about balance. Can the system provide transparency while still protecting the freedom of association? And this is why the FCRA 2026 debate goes beyond NGOs. India is deeply connected to the rest of the world. Foreign universities work with Indian researchers, international foundations support developmental programs, global charities work with Indian organizations, and diaspora communities contribute to humanitarian and social projects. These partnerships can benefit India, and they should not automatically be treated with suspicion. But the more money moves across borders, the more important transparency becomes. Technology has made it easier to move money internationally, and social media and international advocacy networks can spread campaigns much faster. That does not make international cooperation wrong. It simply means that financial disclosure, purpose-based regulation, and effective oversight becomes increasingly important. So ideally, a modern regulatory system should achieve two things at the same time. First, it should make compliance simple and straightforward for genuine organizations doing legitimate work. And second, it should make it harder to hide or misuse foreign funds. It should also have clear procedures, reasonable timelines, meaningful review, and safeguards against arbitrary or discriminatory enforcement. If the 2026 framework can achieve that balance, it could strengthen public confidence without unnecessarily weakening civil society. But whether it actually achieves that balance will depend on the final legislation, the rules, and how the authorities put them into practice. So, where does all of this leave us? The FCRA debate needs to move beyond simple slogans. Foreign funding is not automatically a problem. An organization receiving foreign funding is not automatically suspicious, and regulation is not automatically repression. But at the same time, simply calling something transparency does not automatically make every restriction proportionate or every enforcement decision fair. The real test is this: are the rules transparent, proportionate, predictable, and applied equally? India benefits from genuine international philanthropy, research, partnerships, and humanitarian cooperation. Those channels should remain open. But India also has a legitimate interest in knowing who is financing organizations operating within the country and how that foreign money is being used. And this is where the 2026 bill becomes particularly important. It goes beyond simply asking organizations to disclose their foreign funding. It proposes a more detailed system for dealing with assets when FCRA registration is cancelled, surrendered, allowed to expire without renewal or not renewed. There is a mechanism for restoration. But there is also the possibility of permanent vesting and disposal if the organization does not regain the required status. And that is why the bill matters. The question should not be, do we choose civil society or national interest? A mature democracy should be able to protect both. A balanced approach would allow legitimate international cooperation, protect the independence of Indian institutions, demand genuine financial transparency, and provide fair safeguards for organizations that follow the law. Because when money crosses borders, transparency should cross with it. But so should due process, proportionality, and accountability from the regulator. That's all we have for now. Keep watching Hornbill TV.